Compliments of the season to you and welcome on another edition of the Scale of Justice on the Nigerian Television Authority, the NTA. The 2023-2024 legal year witnessed some landmark pronouncements of the courts that shaped the constitutional democracy being practiced in Nigeria. One of such verdicts is the Apex Court's position on the financial autonomy of the third tier of government. This episode will equally feature a reflection on the country's efforts on improving the criminal justice system. These and more will be coming your way on the Scale of Justice this week. I am Dele Atumbi. One of the building blocks of constitutional democracy is the interpretation of the law as it is. This was done in the case of the Attorney General of the Federation versus the Attorneys General of the 36 states of the Federation on the financial autonomy of local governments. On 11th July 2024, the Apex Court ruled in favor of financial autonomy for the third tier of government. The Scale of Justice speaks with the Attorney General and Commissioner for Justice of Nasarawa State, Dr. Shuaibu Labaran, on these development and other sundry legal issues.
Yeah, 11th July was a remarkable day in the annals of history of the judiciary in Nigeria. I say that because that was the very day the Supreme Court handed down a judgment upholding the position of the Constitution of the Federal Republic of Nigeria, granting financial autonomy to local government as the third tier of government. And that is a significant decision that is geared towards enhancing rapid development at the grassroots level. The system where money credited to the local government goes to them directly, not through the joint account committee of the local government in the respective states as contemplated by Section 162 of the Constitution of the Federal Republic of Nigeria. Now, the merit of this judgment is to see that development has reached the grassroots. Local government chairmen are guaranteed of their tenure. They have what we call security of tenure, because once you are elected on a particular number of years, that judgment see to it that that tenure is guaranteed, is secured. No governor will wake up in the morning and announce that any local government is removed without following the due process of the law. This is one of the significant and the merits of this judgment. And aside from that, it is also one of the advantages of this judgment that no money credited to the local government goes through the state account. So the independence given to the local government, particularly the financial independence, is actually to reach the people at the grassroots level. However, the question is whether the impact of this judgment is being felt. Well, for us in Nasarawa State, we have set the ball rolling. One, we have a democratically elected officials at the local government level. Number two, His Excellency Engineer Abdullahi Esule, the governor, whose mantra is on three thresholds, especially within the justice sector: access to justice, rule of law, and human rights, now did not hesitate to see to it that the law establishing the local government law of the states, 2018 local government law, has been quickly amended. In fact, not only amended, but repealed to reflect the realities of the pronouncement of the judicial pronouncement of the Supreme Court by immediately abolishing what we call the Jack Committee at the state level and directing that all monies credited to the local government should go to them directly. This is a very significant development that requires bold step by any sitting governor to actually actualize it. But the issue is whether those monies from the federation account is going to the local government directly as we speak. That is another question that is yet to be answered. Now, I'm not in a position to speak about that, but what is clear is that the local government law has been amended in our state, and it reflects the real position of the wordings of the Supreme Court in its judgment delivered on the 11th of July. It's really going to bring about transparency and accountability, because once money goes to the local government, the people that will be interested in how those monies are spent are actually the people at the grassroots level. And the transparency in it is where the federal government made it very clear at the end of every FAC meeting that this is what amount that is due to each of the local governments. So it is easy for the people that those monies were meant for to track the expenditure. And of course, you have the legislative arm, which is a composition of councillors representing the entire wards that make up the local government, that can also sit and look into the finances of the local government. And beyond that, the entire people of the local government are also interested in seeing how their monies were spent by the respective local government chairmen. Let me say without mincing words that the pressure on the judiciary, especially in 2024, cannot be compared with what happens in 2023. Because 2023, no doubt, was election year. And of course, there were spillover of pre-election matters. There were also election tribunal, appeal panel, and of course the Supreme Court. So the pressure on the judiciary in 2023 really cannot be compared with what really transpired in the 2024. So I would like to say, without mincing word, that the Supreme Court, the judiciary generally has done creditably well, largely because of the lesser pressure compared to the previous years that I've said. And you can see from the pronouncement of the Supreme Court in recent time, you could see where the Supreme Court gave judgments empowering the EFCC. We also saw a situation where the Supreme Court also gave judgment, also empowering the NFIU, the Nigerian Financial Intelligence Units, to issue regulations to check the excesses of the spending of states, local government, and indeed individuals, and of course track financing of terrorism and other criminal acts. So these pronouncements were very critical to the growth and development of Nigeria, and the EFCC are further empowered by the recent decision of the Supreme Court to check all financial crimes, irrespective of where it is. In fact, it was really defined where there was a challenge as to the constitutionality of the existence of the EFCC itself. The Supreme Court came bold to say, look, this is a creation of law validly made by this relevant legislative arm to establish such body. So I think from all that have been transpiring, the judiciary has fairly dealt with issues that borders on national development. Again, if you look at the issue of the lottery case, which the Supreme Court has also handed down, now giving every state the powers to also enact its own laws regulating lottery in its states, not centralizing it. So I think we have had a lot of monumental development in our judicial system, and the fairness cannot be compared to anywhere. So, and that is the reason why you see almost all the judgments that were handed down, none of them was criticized, and the judiciary was really thumbed up by the entire citizenry for coming up with such a very robust decision. And again, very importantly, we came in a year where the take home of the judicial officers were also enhanced by the government, and we witnessed a situation where there was a transition in the leadership of the Supreme Court. So all of this characterize the development that we have had in our judicial system, and of course, it's further strengthened the system. So we are really happy that we have achieved this, especially that the Supreme Court is now experiencing its full complement with 21 judges. So these are some of the things that characterize and shape the judiciary in this year. Let me say, without mincing words, that as the Attorney General, I'm having the best of my time at the helm of affairs of the justice system in Nasarawa State. And my reasons are very, very simple, straightforward. I have all it takes, the enablement, to actually discharge my responsibility from any form of interference. And that exemplifies the rule of law. And His Excellency, the Governor of Nasarawa State, Engineer Abdullahi Sule, has the requisite exposure to understand the non-interference into the justice system as a panacea for any form of development. And every other act of governance must be in consonance with the principle laid down by the rule of law. This is what characterizes a very formidable state that has fortune for development. And this is one of the things that is really attracting investment in our state today. If you go to Nasarawa State is a hub of solid mineral, lithium. Nasarawa State has the largest deposit of lithium discovered in Nigeria today. And all of this, the investors that have come into Nasarawa State wouldn't have come if the Nasarawa State is operating in a lawless environment. So the issue of rule of law has taken the center stage. For every decision the government is going to take, the first thing to be reckoned with is what is the position of the law with respect to all of this. And we quickly switch in, and that is the reason why the state is in a cruise control, where the institutions are getting to be strengthened by the day. And once you have once the institutions are strengthened, then certainly development will always find its way. Nasarawa State is about the most peaceful state in the north-central Nigeria today, not because of the number of military or armed policemen in the state, but because Nasarawa is centered on justice. And where you have justice, certainly peace will always find its way. So, taking advantage of the justice system, Nasarawa State has little or no challenge in carrying out its activities that will gear towards the needs of the common man in Nasarawa State. So the governor is doing extremely wonderfully well. Now, the justice system of Nasarawa State is so simple that every citizen with any grievance have access, unfettered access to justice. You will be listened to and you will be heard. Your grievances will be taken and certainly justice will be delivered. we came a situation where we found out that within the corridor of the Karu axis, we've been having issues of land grabbing, issues of some crimes here and there. It didn't take us any magic to actually sanitize that corridor. And today, that corridor is one of the most peaceful corridor you can find, because we've initiated a lot of policies that really sanitize the system. So you go the judicial sector in that axis, very perfect. The police in that axis, very perfect. And we give credence to our law enforcement agencies because they operate like a family, share intelligence. There is no any issue of rivalry amongst them. Nobody is taking any credit for one thing done or the other. So it is a collective responsibility. And under the watch of the Attorney General, a lot of things are put in place in accordance with what the law says. So we have a seamless operation in our states, and that is what really demonstrates the kind of system that we operate. And let me end this thing by really giving a very huge appreciation to the wisdom given to the Chief Judge of the state, Honorable Justice Aisha Bashir Aliyu. She's a lady, but very, very down to earth when it comes to issues relating to discipline. And she is also up and doing in ensuring that we have a corrupt-free judiciary in Nasarawa State. She is also in place, liaising with the executive arm of government to ensure that there is no any hitches or interference with the work of the judiciary in the state. However, that has not compromised the legitimate, earnings of all the judicial officers in the state. So these are some of the things that we are really doing, and of course we're having it very, very interesting. And all this give thanks to the understanding given to the judicial sector by His Excellency the Governor of Nasarawa State.
The pronouncement of the Court on Financial Autonomy of Local Governments is to aid grassroots development. Hence, those at the ends of affairs at the local government level should ensure this is achieved. Moving on now to the country's criminal justice system. The Federal Republic of Nigeria is making frantic efforts in improving its criminal justice system. To this end, the country's anti-graft movement is gaining more ground on the prosecution of the defendants allegedly caught in the web of financial crimes. Austin Ayebe reports.
Keying into the Renew Hope agenda of the present administration, the Ministry of Justice embarked on several judicial reforms to make the administration of the criminal justice more efficient and effective. The Attorney General and Minister of Justice Lateef Fagbemi, Senior Advocate of Nigeria, realizing that many of the subnational governments are culpable of being involved in financial crimes simply because they indulge in the management of local government funds, approached the Supreme Court to get the financial autonomy for the local government.
He has created a platform, an enabling environment for the Ministry of Justice and the private sector, the civil society, to work together. That's commendable. I also salute his effort at local government reform. For me, if that can work, it's going to make a lot of positive impact.
It is only somebody who has faced those challenges in criminal trials from state to state as they differ that will understand the need to harmonize and have a uniform system operating all over Nigeria, all over the courts, so that what you get in the court in Abuja is not different from what you get in the court in Sokoto, so that what you get in Sokoto is not different from what you get in Port Harcourt.
Not relenting in its effort to fight corruption, the anti-graft agency EFCC has continued to prosecute those investigated and alleged to have committed financial crimes. Prominent among people with financial crime cases before the courts in 2024 include the former governor of Central Bank of Nigeria, Godwin Emefiele, who is still facing trial in multiple courts with varying counts bordering on alleged embezzlement, misappropriation, and money laundering. The case of former governor of Kogi State, Yahaya Bello, is also before the Federal High Court and the High Court of the FCT on alleged financial crimes amounting to 110 billion naira. While he was denied bail by the High Court of the FCT, the Federal High Court granted him bail with a sum of 500 million naira with two sureties who must have landed property within the jurisdiction of the court. A former Minister of Aviation under the administration of President Muhammad Buhari, Hadi Abubakar Shirika, and his brother were arraigned before Justice Begori of the High Court Garuki. They were arraigned on a 10-count charge bordering on contract fraud to the tune of 5.8 billion naira, which they pleaded not guilty. They were subsequently granted bail with a sum of 100 million naira each with two sureties.
There are cases that have gone on for the past 10, 6, 7 years, and there's no, the date when they might be concluded is not in sight. Even when you conclude the trial, they can go on appeal. But plea bargaining gives you a certain closure within a limited period of time.
Another criminal trial before the court was that instituted against Binance Nigeria. But in October 23rd, the Nigerian Anti-Corruption Agency dropped a money laundering case against the top cryptocurrency executive Tigran Gambaryan. The Nigerian government had accused Binance of manipulating the local currency through peer-to-peer trading on its platform. It subsequently slammed tax evasion, currency speculation, and money laundering counts to the tune of $34 million against its executives. There were other cases of cyber crimes that took place in 2024. Commenting on how the courts have fared in handling criminal cases, legal experts say it was challenging. But with the ongoing reforms under the Renew Hope agenda, they said things are getting better.
We need to reduce the number of times that witnesses are physically needed to come to court. We need to come up with a system where testimonies can be taken without them physically being in court.
We have common, similar minimum standards. In other words, everywhere you go in Nigeria, you can expect that you will find these provisions there. That's one.
To expedite criminal trials, they have this suggestion for the critical stakeholders in the justice sector.
I think apart from the judges, apart from the investigators, apart from the prosecutors, it is important that the authorities, and I appeal to the NJC particularly, to set a deadline for e-recording to become the normal practice in our courts.
They expressed optimism that 2025 will be better, going by the reforms embarked upon by the Ministry of Justice.
Now to the decisions from our various courts.
The Legal Practitioners Disciplinary Committee, LPDC, has rejected a request by Emmanuel Chambers, the law firm of a senior advocate of Nigeria, Afe Babalola, who in his bid to revoke the law practicing license of a legal practitioner and author, Dele Farotimi, has charged him over allegations of criminal defamation and professional misconduct. Farotimi was brought before the LPDC based on a petition. The petition alleged that Farotimi, in his book, made defamatory statements against the Supreme Court and the legal profession, that the name of the author be struck off the role of legal practitioners in Nigeria. However, after looking into the reports, the LPDC determined that the alleged offenses occurred in Farotimi's capacity as an author and not during his practice as a legal professional. The LPDC, in its ruling, concluded that it lacked the jurisdiction to address complaints about publications and advised the aggrieved parties in the matter to seek redress in regular courts. Meanwhile, the Economic and Financial Crimes Commission, EFCC, has arraigned a businessman, Akindele Akintoye, before Justice Emeka Nwite of the Federal High Court, Abuja. He was arraigned on charges bordering on money laundering and contract fraud. He was alleged to have collected $35 million from the Nigerian Content Development and Monitoring Board to build a 2,000 barrel per day refinery, a gas plant, and a tank farm in Brass local government area of Bayelsa State. When the charges were read to him in court, the defendant pleaded not guilty. In view of his plea, the prosecution requested the court to remand Akintoye in a correctional center before the trial would commence. However, his defense counsel applied for his bail. After looking into the facts of the case, the court ordered that Akintoye be remanded at the Kuje Correctional Center.
That's our package for this week on the Scale of Justice. See you next week for another edition of the program. Thank you for being part of the program. I am Dili. Bye for now.